Ladies and gentlemen of the jury, you are the winner. You are the jurors who have to decide questions of fact and questions of law based on what I am going to say to you. This is my last will and testament before I die. I am going to be soon 84, and I've got saddest memories what happened in the United States of America for the past 42 years, a case that never ends. Same is the case in India. I will not go at this time what is happening in the state of Kerala where I was born. I will take another occasion to explain what happened in Kerala. We can combine these two. I am only going to speak to you what happened to me when I left India in the year 1968 for UK, where I happened to work for Her Majesty's government as a post and telegraph officer in London. My 3 daughters were born in England. We used to live a couple of places after we bought the home for a paltry deposit of $500. Those days things were cheap. Many of the homes didn't have bathroom or shower, so to say, not bathroom, shower. Didn't have TV. I'm talking about the 1968. After working for Her Majesty's government for 7 years, my 3 British-born daughters, namely Aislinn, Hainer now, Anna Talakotu, who still have the same name, who is a budding actress in Hollywood and who studied in Australia for some time, and my youngest daughter, Julia Bennett, now, who is the chairwoman of a company called Bennett Aerospace. We moved to America, the land of opportunities, thinking we will have a better life there. They did all come with me or with my wife at that time. I went there first to find out whether I can get a white-collar job. As I was told in those days, most of the highly educated people who went to England or to America, they were working on menial jobs, driving a taxi or some factories where they make batteries, very dangerous situation. Luckily for me, the very first day I landed in USA, I got a job with a company called Michigan Bell Telephone Company. In short, we call MBT. That's a short form used. MBT means Michigan Bell Telephone Company. Within a few days after I got my social security number, --5 and 7667, we don't want to give you the whole numbers because somebody can use it. I started work for Michigan Bell as a clerk. Within a few days, my immediate boss, by the name Jack Temple, called me to his desk and wanted to find out from me my educational background, my experience, etc., which I explained to him when I was working in India, where I was a secretary working for a company called New India Assurance Company in their regional office in Connaught Place in New Delhi. I also happened to work during my final year LLB for the retired Chief Justice of India, Dr. Teja Singh, who was one of the justices in the Supreme Court of India during the British time, for a short time. Once I explained to him my experiences abroad in India and in England, Mr. Bart's, Mr. Temple, Jack Temple, sent me to take a test. I took a test. I passed the same in flying colors, obtaining 100 marks in every area of assessment. And I was sent to work for a male gentleman by the name David Bartz, which my research showed it was a German name. Upon entering his office to work for him as his secretary, he was surprised. He admitted he never had a male as his secretary any time during the years he worked there. I am the first person. He doesn't want to hire me. This is the first thing what happening. So he called the central personnel who told him, you have to take Mr. David. He has met or far exceeded the qualifications required for a secretary. Mr. Bartz willingly accepted me as his secretary for a period of 3 or 4 days. And he found me unfit for his purpose. What it is, I don't know. I'm a male, I don't sleep with him. So if that is what he meant, he wants young girls. Whatever purpose. Bart's dead, all the guys died since then. Anyhow, I filed a EEOC complaint. The EEOC came and investigated, found MBT guilty of gender discrimination and also violation of the national origin discrimination cases. And I was ordered, and the MBT was ordered by the EEOC to resolve the matter and ordered them also to pay me a nominal compensation. And I reinstated. I went to work for 4 managers, not one. One is a German by the name, I can't believe his name, Raymond, his name is Raymond Schneider. Another one, a French by the name Delisle, Delisle, I believe he's a French, and an American black by the name Bob Cooper, and another guy by the name anyhow, the 4th one was an American white. All these guys found to be overqualified. They sent me to take a MAP. MAP means Management Assessment Program, at which I got a perfect score. That is, they watch you remotely, maybe 5 miles away, different locations, watch everything. They give you mark. I got 100 out of 100 in each area of assessment. But Michigan Bell, MBT, will not promote me nor disclose the test result. All these companies, especially the one in Michigan, they were very, very biased and prejudiced against the people from other countries. Okay? I was forced to file a retaliation complaint against Michigan Bell, and as a result of my second charge, they settled that case also and sent me to work for their then parent company, AT&T, as a legal analyst. There were 1,500 people working in Orlando at that time. Most of them were from different companies, 22 Bell operating companies or subsidiaries of AT&T, including 59 others from Michigan Bell. While working there, I used to get a merit increase every 6 months because I was a junior. The last merit increase was given to me in the sum of $5,000 a week before my illegal termination of employment in 1981. Okay, you have to understand the whole situation. AT&T and Department of Justice had mutually agreed to settle the monopolies case the US DOJ had brought against AT&T under a deal worked out by President Reagan, who was then elected. You have to understand the whole scenario which I'm learning by going through the history. Ronald Reagan was very pleased with the political contribution made by a priest, a Catholic priest by the name Raymond J. Donovan, right? Donovan? He's a Catholic priest. He conducted a Frank Sinatra and he collected a lot of money. He gave to President Reagan, 600,000. Now, President Reagan was pleased with his contribution. He nominated Raymond J. Donovan as the Secretary of Labor at that time. As soon as he came to power, he wanted to abolish all the laws on the books by telling the EEOC not to do any investigation. I was fired illegally while working for working for AT&T, and these companies had offered the 1,500 of us 3 years salary as a severance pay, but not me. They offered me $35,000, which I declined then and there because I had a family of 3, then four young children aged 3, 7, 9, and 12, and my dependent father and wife. So I refused to take it. The next day, Mr. Stone wanted me to go and meet him at a hotel where he is staying in Disney World in Orlando, and he ordered me also to bring my wife with me, and thinking that meeting is for an assignment in Saudi Arabia to where I had applied previously. We went there. We met Mr. Richard Stone at the lobby of the hotel. We were asked to sit down in a vacant seat, and he said, "Mr. David, we'll give you $45,000. You want to take it or leave it?" When he came back in 5 minutes or 10 minutes, we told him, "We don't want the money, sir, because I have the small children, and the company provided various medical benefits, insurance, life insurance, dental, a lot of benefits. So I said, we don't want the money." Mr. Stone, without any prior notice or warning, I was fired in the invited presence of my wife, which caused her serious mental and emotional problems from which she never recouped. She died in the year 2020, December 2nd. I didn't have a chance to meet her, although she came to Kerala some 6 years previously. She wanted to meet me at her church, the Roman Catholic Church. She started crying, and she asked me to buy her some grocery for her to take it to USA from the Indian shop. That's the last time I met my former wife. I was never told her condition. I was kept in the dark by children. Now, coming back to the tactics employed by AT&T in Michigan, well, they contrived various schemes The trial judge, John A. Reed, denied their motion to dismiss the case, interposing release as a defense, which I was forced to sign while on a job hunting trip to Michigan on August 25, 1981. So the defendant's argument was, I signed a release, it should not be investigated by the EEOC, and Judge Reed denied their motion. The EEOC, who had issued me a right to sue letter, the right to sue letter had certain numbers, which I am going to fill in shortly, whereby they refused to investigate the case of an illegal termination of a permanent employee. Okay, there was discrimination based on national origin, color, age, denial of ERISA benefits, employees' retirement income security benefits, and breaches of contract. 4 counts I sued them. I soon after engaged a lawyer from Chicago by the name Cyriac D. Kapil, who was a then president of the Catholic Association in Chicago, and he was a permanent is a member of the bar who represented the Indian Prime Minister Morarji Desai in a defamation case brought against him by Seymour. These are all matters came to light much later. Now coming back to the issue here, the EEOC refused to conduct the trial. They refused to investigate the case of illegal termination. Okay? They are by law required to investigate when an employee who is working for a federal contractor is terminated in accordance with the law then in force. AT&T was then, now, and will continue to be a federal contractor. So there are different standards when a federal contractor violated the laws. So AT&T was so powerful politically, economically, and they can mend and they can do a lot of magic. That's the corruption. Money corrupts, absolute power corrupts absolutely. Now, I took AT&T, Michigan Bell, and others to the court. Judge Reed, John Reed of Orlando District Court, to whom the case was assigned randomly, held that the release is not valid pursuant to the standards set by the U.S. Supreme Court in another case called Alexander versus Gardner Denver, that was decided in 1974. You can Google it, you will get it. We will show it in details. Defendants moved the court to dismiss my pro se claims. Judge Reed denied their motion, citing Alexander versus Gardner Denver. Subsequently, I went to Chicago, hired a lawyer by the name Cyriac D. Kapil, who was from India, from Kerala. I engaged him. He came along with me, spoke to my wife and children to find out whether I am telling the truth or not, because the children were with me, with my father, picketing in front of AT&T, because they illegally terminated. Before we went for picketing, AT&T sent an undercover agent by the name James R. Williams to my home, who came uninvited without any notice, persuading me not to conduct any picket. And as far as I knew, and the old colleagues knew, he always carried a gun on him. Those days, there was no restriction for anyone to carry a concealed weapon. Okay? James R. Williams was an undercover agent sent by these companies to kill me. But hearing the commotion, my whole family, children, father, everybody came to the scene and avoided what would have been a murder scene. Thank God. We picketed. It was on prime time television and newspapers. The channel said, Channel 2, I believe, Little David's fight against the mighty Goliath. Right? It was in every newspaper. AT&T doesn't want to settle the case. You understand? They tried to bargain with my counsel, Kapil, to make him a district judge in Cook County, which he declined. They also offered him some plum cases to handle on their behalf, which too he declined. Then they started threatening him and propounded 1,350 interrogatories or requests to admit, which is not normally the way lawyers conduct EVT or deposition. Kapil responded to that interrogatories, although he felt and thought it is overly broad and burdensome. He was subsequently murdered. Judge Reed, before whom he appeared, he argued that the release is no good, and he filed an amended complaint which judge admitted and refused the defendant's motion to dismiss the case, interposing release as a defense. After my counsel was murdered, which I didn't know because I couldn't afford to pay him a huge retainer, we mutually agreed to part company and I took over. Then what the defendants did was secretly hire the trial judge, John Reed's former law clerk by the name Ann C. Conway. According to my research, and as admitted by the trial judge John Ray Reed, they were meeting at each other's homes in violation of the canons of ethics and the professional responsibility. A judge and his former law clerk who represent the defendant cannot meet each other to discuss how to dispose of the case. Folks, thus far I was not looking at any papers in my possession. I told you the EEOC issued me what is called a right to sue letter. The right to sue letter is number 054-821178 and 054-82-1288 dated April 12, 1982. We're going to show you the right to sue letter, which I discovered, which I have it. But the contention of the employer was that the release should be given due weight, which according to the Supreme Court has no validity because the release must be signed by the employee freely, voluntarily and knowingly. Here in this case at bar, there was no knowing, the meeting of the mind. The defendant extorted me and forced me to sign the release in order to feed my young children. Okay, so in the eyes of law, the release is no good, as ruled by the U.S. Supreme Court in Alexander versus Denver Gardner. Then the scheme was have this woman on Second Way meet the judge, the trial judge, at his home, at her home, and other undisclosed places in Atlanta. Why? If they have such a meritorious defense, then they should conduct a trial. This crooked company, I call a mafia company, I still call them because of the way they conducted their business. This woman was violating the canons of ethics of the Florida bar. The judge was violating the canons of ethics of the American bar. You are co-conspirators. So, under the scheme, Saul's scheme, Judge Reed transferred the case from his court in Orlando to Tampa of the defendant's choice forum. The judge who is recusing and resigning from the bench has no option, and it has to be decided randomly pursuant to the rules, which he doesn't want to. The deal by the judge and this woman with AT&T was they will transfer the ball from one player to the other and they will continue the same game. I was living in New York at the time, and I moved the court to transfer the case from Orlando or Tampa to New York. Hodges refused. He ordered me to appear before him for a status conference, and he held. This case has been transferred to him by the outgoing judge who resigned for a cause. And by force, he decided to have the case there for a period of 4 years. The rules, federal rules of civil procedure mandate a court should dispose of the case within 2 years. So he was breaking the law. He was dealing under the table. Understand? Now, several things happened. When I reached my retirement age of 60, I filed a claim for my benefits. Benefit means I had contributed to the ERISA. I had paid X amount of money as a non-management and as a management employee of these two corporations. You understand? According to the law, I should get 100% benefits from these two mafia corporations. Now their alibi or pretext is they lost my employment records. Can two federal contractors, Michigan Bell and AT&T, can they hire somebody without a social security number? They can't. That's a violation of the law. But they say they lost my record alone, although they had millions and millions of employees. I researched, I found out the Jamaica office in New York had my complete employment records. To get them, I had to pay $35 each year. So I had to pay 32 or 35 times 42 years. I can't afford. I'm living on a partly below the poverty level income from the Social Security. Social Security is a different pension. I'm getting it every month unless President Biden didn't sign the debt bill by end of next week. Otherwise, if he doesn't sign, the whole entire United States missionaries will go without any money. There won't be anybody to work for the US government. So that we can wait and see before June, before May 31st. Okay, that's something you have to watch, everybody. What is going to happen? The billions and trillions money the US government has borrowed from the public. Now, coming back to my issue here, if it's a fair game, why should they be afraid to have a trial? That's the question for the juries to decide. But they don't want the jury to hear the case. They don't want a bench trial, neither a bench trial or a jury trial. This sucker judge, Terrell William Hodges, never wanted to conduct a trial. He was in cahoots with. When I reached, as I said before, my 60th birthday, 66th birthday, so to say, I applied for my pension. Now, this judge, so they pick and choose the puppets. There is another scheme, bigger scheme. Anybody who practice law in the United States know, including President Trump and Biden, how the game works. They can pay money under the table to the clerk of the court, who is in charge, and have the case heard before a panel of their choice. If you want a Republican president, a Republican player, then they know how to give it to the Democrats and vice versa. So this woman in Orlando, Florida, in Eastern District of New York by the name Seibert, Joan Seibert, she ordered, you have to hear the funny thing, a lower court judge in New York ordered another court in Tampa, after 20 years, my record. Have you heard of that? A judge, district judge in Tampa, was ordered to provide to her my employment records. And they engaged a major law firm from New York by the name Fulbright and Jaworski, now known as Norton Rose, Fulbright and Jaworski. They selected the chairman of the political party by the name Ralph Curtis Dawson. Curtis Dawson, what he does is, he calls a brand new lawyer, just walked out of law school, my research showed, from the St. John's University, where this judge herself was graduated previously. Dawson instructed this newly worked-in lawyer, Brian Wayne Tilker, to file an affidavit. So this puppet law clerk, the new counsel for Dawson, files a 3-page affidavit testifying his personal knowledge when I signed the release, which is valid, and he is attaching a copy of the release. So, under the rules, the judge is required to conduct a trial to determine whether the release is valid or not. This judge's name is Joanna Seibert. Under the Federal Rules of Civil Procedure, a judge is required to conduct a hearing. She doesn't want it. Neither Dawson nor Tilker. They never ever came to the court. Never ever. They managed everything through what we call Charlie's Angels. Charlie's Angels. If you have seen the television show, Charlie's Angels, you know how Charlie's Angels operate. So this woman, Seibert, without allowing me to present evidence, which was stated by the defendant's counsel after my counsel was murdered for 3 days, she excluded them. She only concentrated her decision based on Tilker's affidavit. And she grants a summary judgment denying my pension. You understand? When I researched from the New York bar, I learned, to my surprise, Tilker, at the time I signed the release in Detroit, Michigan on August 25, 1981, was only a child of 3 years old. 3-year-old Tilker testifying his personal knowledge. And this rat, Seibert, granting a summary judgment based on 3-year-old Tilker's affidavit. I presented her with evidence showing at the time Tilker testified he was only 3 years old, being born on May 5, 1979. Oh, Mr. Dawson got a shock of his life because he had, what they do is under the scheme, he submits a cover letter to the court, which means signal how to handle it. Okay, the affidavit is nothing but a phony one, as you see. Now I asked Seibert, Your Honor, your judgment is erroneous, false, based on hearsay, because 3-year-old Tilker, who was then living in New York, cannot testify what happened in New York. In New York, Tilker was living in New York, and this woman is living, having her office in 600 miles away. So his affidavit was false. Folks, the name of the game didn't end there. Okay? What I wanted to say to you guys is that the whole operation was based on fraud. Fraud upon fraud. I submitted a petition for a writ of mandamus before the Supreme Court. The Supreme Court, while denying my motion to proceed in forma pauperis, because I thought my case be heard without paying the fee, because I don't have income. I was on, based on American standard, $40. The court said in its order, unless Mr. David pays the fee and submits a petition. That's the order of the Supreme Court of the United States of America. You will see a copy of the order. Now, the clerk of the court refused to take the fee. I paid $300 bank draft and 40 sets of the brief as required under the Supreme Court rules. You understand? The Supreme Court of the United States says, unless Mr. David pays the fee and submits a petition, and when I paid the fee and submitted the petition, the clerk of the court won't accept the same. As I told you before, because we are shooting this part by part because of different interruption, and I may sometimes forget things. The affidavit was submitted by Tilker when in New York. The proceedings were going on in Michigan, which is 600 miles away. So the judge, whatever I said, you have to listen carefully, because you can't grasp everything in one sitting. You have to take it easy, read one section, then take a break, so that you will get a continuity as I am losing my thought. So, the judge in Michigan, by the name Seibert, she is, again, sorry, without any hearing, without any notice, she dismisses my claim, saying that Mr. David waited 20 years to file a claim for my vested pension. Vested pension, if it had been paid on time, I would be in the court, except for my age discrimination and Title VII claims. Now, my pension, which is vested, which is payable 100% by the Department of Labor, never been paid, not by the Department of Labor, by the employer. The concocted story of the employer is, they lost my records. What a strange story. I wrote to the chairman of the AT&T, who is walking away with the $75 million in benefits. I wrote him. I found out hard way, going chasing through several sources, his email address. And he didn't communicate with me. He sent a woman, the HR manager of AT&T, to investigate. And this woman, Colleen Mason, if that's the name, she wrote me to say, Mr. David, you will be the first one to hear from me the outcome of the case, the investigation. Then she writes to me, saying that, Mr. David, you litigated then 37 years, you knew what happened. What happened? They denied my pension. So that is one of the crucial issues in this case. Your social security number disappeared, my pension record disappeared, my files have disappeared. I went to Tampa, Florida in 2020. I went there to picket in front of the US Supreme Court. After I picketed, I went to the administrative agency of the United States courts, where they thought I'm somebody mentally disturbed. They called the security guys, 5 of them came. I said, what did I do wrong? I want to speak to somebody. No, you can't see it. You have to call them. What number? They don't have a number. I am in the administrative agency of the United States courts, and the Department of Justice, without even showing the name of the writer, says, we can't investigate. If the Department of Justice cannot investigate a case where there is fraud and corruption, who else can? How can you communicate with an agency who you don't have a number or the email address to? Finally, after impounding my US passport, They let me go, and I didn't realize they had my passport. I was sitting behind under a tree waiting for my cab driver to come. Then they came to me and then gave me my passport, my US passport. Folks, this is not a tale. This is the real thing happened. And this is my dying testimony so that the world will understand what the heck going on. I'm going possibly next month. I don't have the funds yet to buy even my ticket, but I will go there. I will stand in front of the federal courts and the EEOC and all these kangaroo court players. The most corrupted agency was the EEOC, who should have investigated my claim for illegal discharge. They can say, we don't have the record. Is the failure to keep my record my fault? The EEOC should have investigated. They should have found out what is this reference number. The number I quoted to you, and the case number was, as I told you before, the case number EEOC. The case number I showed you before was 054821178 and 054821288, dated April 12, 1982. So, is the US government's fault not to maintain records, destroying them, to cover up, to protect this mafia corporation? These are vital questions. Now, after the Supreme Court clerk, there are several clerks involved in the scheme. Supreme Court sits, the justices of the Supreme Court lives or conduct their proceedings in another building. The clerk's office is another place. Now, the justices don't get my papers unless it is submitted to them. So the next game is prevent submitting my papers. I submitted the fee, $300. It's a draft, bank draft, not a check, obtained from the ICICI Bank, which I closed later on for other reasons. And a second check, which is also from the same bank, ICICI Bank, requesting Justice Thomas, assigned to the 11th Circuit, to Justice Clarence Thomas of the US Supreme Court, I'm sorry. They never submitted to him. The issue I raised before the Supreme Court was, how can a retired judge from the 11th Circuit hear my FRAP Rule 35 motion? FRAP, Federal Rules of Appeal Procedure Rule 35, which requires review by a panel of 3 active judges, not by a retired judge. It was never given to an active panel. Why? The 11th Circuit is the only circuit out of the 13 circuits in the United States which has a rule contradictory to the other circuits. And the Supreme Court has jurisdiction when one circuit has a different rule than the other 12 circuits. That's the reason why I filed my writ. J.L. Edmondson, who was one of the members of the original panel when I filed an appeal, he had retired by then on July 15, 2012. The motion is filed in 2015, 3 years after he retired. Can he review my papers? No. Under the rules, Federal Rules of Appeal Procedure 35, it should be heard by 3 active judges. That's where the Supreme Court should come into the picture. But that is what the clerk of the court and subsequent clerks are refusing. I took the clerk of the court, who refused to conduct his business pursuant to the rules, to the disciplinary committee of the bar, because he is a member of the district. He is a member of the disciplinary committee. He is not a member of the disciplinary committee, he is a member of the bar. Scott has Harris. There are no special rules for the clerk if they violate the rules. The clerk of the court is the one who sees the justices every day. He could have told them, the court has issued an order, we are not going to do anything because we are trying to protect the corporation. So justices never got it. DC Circuit, Disciplinary Council, hogwashed. They didn't even docketed the case against Scott Harris. A woman by the name Becky Neal, the lowest clerical employee of that disciplinary council, held Scott Harris has not done anything wrong. How does she know? If a clerk refuses to carry out his job, the disciplinary committee has the right to question. But she doesn't want to. You understand? Everywhere the same game. Then what happened? I was forced to file a new complaint with the Columbia Circuit Court of Appeals, Columbia District Court. That complaint was having 32 pages. Under the rules, once you file a complaint electronically, as was required then, should be automatically assigned a judge and a case number. It took 3 months for AT&T to pick a judge from the Columbia District Court, pick one of their choice. You understand? This is the name of the game. The rules require, the Columbia Circuit rules require you file electronically, not paper-wise. When I filed it, they want to assign this to a judge for 3 months. So after having shopped around which puppet judge the case should go to, it goes to Judge, what's his name? Do you know the name of the judge? Deal, will give you the name of the judge, and this judge says, Mr. David, your brief containing 32 pages is too long. 32 pages brief should be too long to explain what happened 42 years. You should reduce that to 15 pages, double spaced, under Rule 8 of the Federal Rules of Civil Procedure, which when I checked says nowhere that should be limited to 15 pages, double spaced. You understand? Now, I was happy with his decision. He wants me to do it and cut down my exhibits, the proceedings, that is the exhibits. I appealed his decision to a 3-judge panel in the Columbia Circuit, and they held the court has no jurisdiction. You have to understand, the court had both equitable jurisdiction and proper jurisdiction, because there's an order of the Supreme Court for which I paid. They rejected taking the money. Okay? So this case went on from one judge to three judges to the en banc, which has 16 judges then as per my count, headed by Srinivasan and other judges, who apparently denied the defendant's argument. And once they denied, they don't put a mask to cover up the order. The clerk of the court did it. If they did, and if it was a true order by the en banc court of the Columbia Circuit Court of Appeals, my next avenue is to go back to the US Supreme Court. So instead of doing that, I'm getting an order from another woman, another judge, Tanya Chutkan. Tanya says, Mr. David, submit your petition pursuant to Rule 8 to 15 pages, double space. Same thing as ruled by Neil, I forgot his name again, the first judge. Okay, we'll put the name. And then from there, it goes to a three-judge panel who issues an order that my petition is dismissed, showing I have not shown there is a meritorious argument. Then I filed brief, and it was written by another clerk. He says, your brief is 7 days late. See, this is the name of the game going on. You are continuing the same process. Then when I submitted weather report from the Indian Geographical Weather Report people, saying that due to flood here in Kerala, I couldn't send these papers on time and I should be given time. So it is written by another clerk. You understand? So none of the players have done what they are required to do. I submitted certain questions for the Supreme Court of the United States. I had presented several issues for the Supreme Court, and one of the questions I raised before the court was the court's prior orders in case number 169624 in re Talakuttu Rod David dated June 21, 2017, allow him to pay the fee and submit the petition, was correctly interpreted but denied by the court's two deputy clerks and chief clerk, and also their refusal to submit a Rule 22 petition addressed to Associate Justice Honorable Clarence Thomas, called for review by this court. When a Title VII ADA ERISA claimant had no other remedy to redress his disparate impact claims. That's one of the questions I raised. Second question, is the denial of review by a 3 active judge panel of the 11th Circuit under FRIP 35, but disposed of by a single retired judge who retired from active service on July 15, 2012, but denied review in 2015 on his own alone without the required minimum of 3 active judge panel, call for review by this court, when such a review ought to have been made by a 3 active judge panel in an employment discrimination claim, especially when the trial court later admitted his clerk had made a grave error in the entry of judgment and corrected the same subsequently under Rule 60A, which I forgot to mention to you. The first trial judge resigned. His successor, chosen successor, Hodges took over, and he didn't do anything. He issued an order, and the order was altered by the clerk as a dismissal on the merits. That was not the Hodges' order. His order was to dismiss the case without prejudice if I didn't tender back the money. So the clerk of the court, he altered that on his own to enable the defendants to move to the 11th Circuit. Later on, I found out that order was defective. I showed to the Orlando district judge, Hodges, that his clerk had altered the judgment of the court. So Hodges subsequently amended the order, retrospective effect from the original entry of judgment under Rule 60A of the Federal Rules of Civil Procedure, to correct the error. So what we have is a corrected order which his successor, Judge Meriday, doesn't want to accept. You understand? So these are all complicated games which are designed solely to let the defendant, this mafia corporation, to get away scot-free. Third question I raised was, is vested and employee contributed pension benefits forfeitable to the employee? Because the trial judge used a perjured affidavit of a 3-year-old Tilker when he later on became a lawyer, and which the Second Circuit refused to make a de novo determination. But by holding petitioner has not submitted a likelihood of success, a boilerplate argument advanced by the Columbia Circuit Court of Appeals that called for review by issuing a writ of mandamus in certiorari. That's the third question. Fourth question, how many times an illegally discharged employee of a federal contractor has to first prove jurisdiction and pay each time a separate court fee or seek waiver, which even this court erroneously held as an abuse of the court's process. And when paid the court fee on a timely basis, it was rejected by the clerk's office, called for review. That's the fourth question. The fifth question is the last question. That is petitioner's illegal termination from employment in 81 and subsequent proceedings at the various courts below, to where he was dragged for nearly 41 years, are to be construed as an abuse of the court's process. The court says it's an abuse of process. It's not my fault. They dragged me to 41 years. The question is 41. Let me read the fifth question. Is petitioner's illegal termination of employment in 81 and subsequent proceedings at the various courts below, to where he was dragged for nearly 41 years, are to be construed as an abuse of the court's process when no other remedies are available to a long-time employee who worked for a federal contractor, who breached every labor laws on the books, executive orders 11246, OFCCP regulations, EOC laws, while the employer had resorted to unprofessional, unethical conduct that called for review, when such illegal and immoral practices have resulted in manifest injustice that called for review by this court. These are the 5 questions I raised. These were submitted, copies of these briefs were submitted to AT&T, 208 South Accord Street, Dallas, Texas, where they are headquartered now, Michigan Bell Telephone Company, 444 Michigan Avenue, Detroit, Michigan, 48226 USA. U.S. Department of Justice, 950 Pennsylvania Avenue Northwest, Washington, D.C. 20530. Secretary of Labor, Francis Perkins Building, 200 Constitution Avenue Northwest, Washington, D.C. 20210. And 5, Scott Heights, Clerk of the Court, Supreme Court of the United States, Washington, D.C. 20543. 00013. And the last person served was the Solicitor General of the United States, room 5614, US DOJ, 950 Pennsylvania Avenue Northwest, Washington, D.C. 20530 0001. This is my sworn affidavit. I am going to show this. I just wanted to show you the questions presented here, and the parties I served, the proof of service. We will bring you a close-up. These questions were never answered by either the Sucker Corporation or any of the agencies. Okay? It means they have nothing to say. These are important questions of law I am raising, and I am entitled to my pension back from the employer under the rules. Not that I am concocting a story, they are avoiding. You understand, folks? I can talk for volumes. I have tons of paper here. Okay? These are tons of paper here. I got a lot of brief here. We got several sets. I sent it to all the people, various organizations, to let the world know what the heck going on in the United States of America. There will be bloody war if EEOC don't straighten, don't do their job. There will be every day, as you hear, murders every day. And those people should investigate what caused those people to take arms. The United States of America has utterly failed, especially under the Democrats. The players, as I've seen, were all Democratic players. The chairman of the Rules Committee, Mr. Dawson, okay, that's one of the top players. His law clerk, the court's clerk, they are all players. Trump is far better than the Democrats. So, all the allegations which is coming in the TV every day, a woman being raped, allegedly raped, 24 years coming up, seeking more money, it's all game. It's all designed to make the people think differently, to cover up fraud. How many prosecutions against President? How many prosecutions against Biden? Biden was doing a lot of hanky-panky in Ukraine. His son was employed there. He was a director. He was made a chairman of a company. Now the world is speaking against. You don't want to say, I'm not part of the political process, but I have a right to speak. What is going on in the country of America? Is the ordinary people getting justice? No, folks. Corporations are coming to India for getting cheap labor. Not that they are coming for India's benefit. They are coming here to save money and pay them pittance in India and get cheap labor. And this is what Indian government is doing now, and it is likely to happen. All right? Thank you, sir. Gentlemen, read this one day at one time. Take a break. We may put this in several parts. I may have forgotten a lot of things which I will once I get back to America soon, will tell the world. Okay? Thank you.